I am accused of stating in the public domain, maybe relentlessly, that legal fraternity has lost all its vitality. I must introduce myself, Mathews Nedumpara. I completely, unequivocally plead guilty of this allegation. I believe the legal fraternity has lost all its vitality. The legal fraternity lawyers have become slaves. That is unfortunate. That is a sweeping statement. But I must say that is the painful truth. Lawyer is the sentinel que vive of the freedoms and liberties of the people. Lawyer is a soldier, watchdog. And if lawyers have become fearful, the lawyers dare not to speak, then even the democracy is at stake. Blackstone said the legal profession is the fourth estate. The other estate being the church, the parliament, and the king or the executive. Today, the fourth estate is otherwise known as press. I am not commenting anything about the press. My concern is about the sad fate of the fourth estate, the legal profession, which according to Blackstone was the fourth estate. Why the lawyers have become a servanthood today? The reason is, as I said, the primary villain is the discretionary jurisdiction, which the courts enjoy, the judges enjoy under Article 226 and 32 of the Constitution. And today Article 226, nobody would dispute that. It is in reality, it's a face value jurisdiction. If the judge likes, relief is granted. If the judge doesn't like, relief is denied. And Article 32, I have often talked about Article 32. Article 32 is a provision which is only unworkable. Because if the Supreme Court is to be the first court of original jurisdiction, and under Article 32, the right to approach the Supreme Court, invoking its jurisdiction under Article 32 for enforcement of the fundamental rights, that in itself is a fundamental right. That is guaranteed. That if every citizen of this country, for the enforcement of his fundamental rights, he could straight away approach the Supreme Court without recourse to any other court, then we don't need any other court. And then to make such a system work, we need at least 1,000 judges in the Supreme Court. So therefore, that Article 32, when it was the founding fathers, when they incorporated it, wouldn't they ever thought of the difficulties it would, how impractical it is. So therefore, the initial days of the Supreme Court, initial years of the Supreme Court, Article 32 worked well, Article 136 worked well. Now today, look at the scenario. For instance, think of Bombay High Court. The writ petitions are heard by a bench of 2 judges. And assuming a judge, it is not a rare thing to happen. It often happens. Dismiss your case without any actual hearing, meaningful hearing. There is no appeal. There is only room for a leave to appeal to the Supreme Court under Article 136. And appeal to petition under Article 136 are decided in 93 seconds. Hardly heard. So therefore, instead of instituting a suit, you are ill-advised to institute a writ petition. Then, and the writ petition relief is denied, then the litigant has lost his case forever. Now therefore, for a lawyer, what matters is the interim relief he gets. A client comes to you, faced with a dispossession, or any other like iniquities. He needs immediate relief. He needs a stay order. The client is only interested in that. And if the lawyer is not able to secure an interim order protecting him, then the lawyer and then the client is, he will leave. He will go in search of somebody whom he thinks can get an order. So therefore this has led to face value jurisdictions. And it's an undeniable fact that in most of the high courts, a large number of the immediate relatives of judges and senior judges practice as advocates. Immediate relatives, sons, daughters, nephew, uncle. So there's in the legal profession today is an industry, no doubt about it. And it is an industry worth thousands of crores of rupees. And this industry is practically monopolized by a few families. Just 1% of the legal fraternity. And therefore that is the reason. And if you now say think of a first generation lawyer, he has nobody, he has no godfathers, and you find judge's son is given a very favorable treatment. The board is discharged. He is heard elaborately at leisurely. He has the same kind of case or same things. He is then summarily dismissed. Then he gets disheartened. And out of frustration, out of pain, suppose he says something, he resents, then he is finished. Because as Justice Joseph has said, that judges discuss about lawyers. And now if you somehow or other happen to stay in a relation with the one judge, the judges, then it is all likely that you will become you will become undesirable. You may face a hostile treatment from many other judges. I am not saying that all judges are like that. There are, even if there are judges who stand with you, that I can vouch for that. But the perception is that is. Therefore, no lawyer would ever, even in the greatest of injustice, he will never dare to react, respond, speak fearlessly. And the Bar Council rule says the lawyer is a duty to be fearless. Fearless of the judge, fearless of the society. If you take up a case of somebody who is perceived to be disliked by the public at large, then the public at large they will be hostile to you, and even a client may stab you in the back. This lawyer is required. The profession requires him. It is his sacred duty to fearlessly conduct his case. But today, if you fearlessly conduct his case, then you are professionally liquidated. And that's one of the aspects. So the discretionary jurisdiction is the main reason. Then the large number of kith and kin of the judges practicing in the same court. So the all legal profession is unfortunately lauded against the first generation lawyers. Now then another problem is with the designation system and the system of collegium where judges appoint themselves. A lawyer today, you have to have some prominence in the profession. To come up in the profession, you have to either become a senior counsel or become a judge. These two, both, are at the mercy of the judges. So if you anyway antagonize a judge, and thereby you may antagonize a community, many other judges as well, then the chance to become to senior counsel is probably lost forever. So to become a judge is lost forever. And in the current scenario, then your career is lost. And therefore the lawyers, they don't dare to open their minds, speaking injustice, and they are, they are, I'm afraid to say, terribly, servile, afraid to speak. Thank you.